my name is Recipients, and I'm an attorney at MNK Law, a boutique law firm based in Los Angeles County. Imagine this, it's 4:30 p.m. on a Friday afternoon, and a document titled Subpoena lands on your desk. You might not even know how to pronounce the document's name, much less know what it means or what to do with it. Today, we'll help you address these issues. A subpoena is simply a court-ordered request for the production of documents and/or a request for a personal appearance at a deposition or in a court. Subpoenas are issued to non-parties after a lawsuit has been filed and where one party believes the non-party has some helpful testimony and/or documentary evidence to offer in the case. One thing to keep in mind, subpoenas types can be combined. That is, they can request your personal appearance and records at the same time. Now that we know what a subpoena is, it would be helpful to know what they look like. This is a copy of a subpoena that has been served in a California state court, whereas this is a copy of a subpoena that has been served in federal district court. As you can see, the subpoenas look vastly different. But the key thing is that both documents tell you, 1, who the subpoena is directed to, 2, what the subpoena requires, for example, the production of records or your testimony, and 3, the deadline to comply with the request. Now that we know what a subpoena looks like, what should you do with it? First, pause and breathe. It's okay to feel that surge of franticness when you are served with a subpoena. But take a moment to stop that frantic mental chatter when the subpoena lands across your desk. Do not let that sentiment control you. Second, do not ignore the subpoena. After you are served with a subpoena, you must make a conscious effort not to brush it aside. Ignoring the subpoena will not make any things better and could actually make things much worse. Ignoring a subpoena could mean that you face monetary sanctions or even worse. Third, determine if the deadlines set in the subpoena work for you. Subpoenaing parties often unilaterally set deadlines for the production of documents or an in-person appearance. Oftentimes, those deadlines are negotiable with the subpoenaing party. So check your calendar. You may not need to cancel or postpone a pre-planned event after all. Fourth, understand what the subpoena seeks. Too often clients call us in an agitated state, assuming without good reason that a subpoena seeks far more information than it really does. Not every subpoena requires you to divulge the entire history of your life or business. So, understand what a subpoena seeks. Doing so can save time and mental peace. Fifth, know that no judge or court will demand you to do the impossible. Subpoenaing parties often take a throw everything at the wall and see what sticks approach when issuing subpoenas. But sometimes it's not possible to comply with a subpoena, perhaps because the responsive records do not exist or never have existed. Do not panic if this is the case. A subpoena does not require you to do the impossible. Finally, contact counsel. Counsel can determine if it can object to your subpoena on procedural and/or substantive grounds, negotiate reductions in the subpoena scope, or seek judicial intervention if needed to protect your interests. So, if a subpoena comes your way, please contact us by visiting our website at mnklawyers.com or email us at info@mnklawyers.com. We'd be honored to help. Thank you.